This is your first time at the Workers' Compensation Court of Appeals? Well, welcome. And Kenneth Jasinski?
Kaczynski, thank you.
Kaczynski. And you've been here a few times, correct?
I haven't. It's my first time as well. So
Wow. Well, congratulations.
thank you.
Well, Mr. Kaczynski, you are the appellant in this case. And so you will be going first. Each of you will have 15 minutes to present your position, but we're going to do a little differently today. Each of you will have 5 minutes of uninterrupted time to state your argument. At the end of the 5-minute period, I will stop you and I will turn to my colleagues and see if we have any questions. And for the rest of the 10 minutes, you are free, in fact, to engage in the continuation or save a couple minutes for closing argument or for rebuttal. But again, you may lose the rest of the 10 just by the questions from myself or my colleagues, okay? Do you have any questions before we begin? Thank you. Counsel, you may proceed. Please step up and you'll see there's a timer there that will show you the full 15-minute time period.
Thank you. Good morning, Judge Mylan. May it please the court. The issue we have today, this is a single issue appeal. It involves the calculation of average weekly wage for a road construction worker, Ms. Buckwalter. The case involves the application of statutes and case law to a largely undisputed set of facts. So I believe the standard of review is a de novo standard of review. To the extent the court considers the conclusion that 315540 was a fair approximation as being a finding of fact, our position on that would be that fact finding is not supported by any substantial evidence. The average weekly wage so far in the proceedings has been set at $31.55 by the compensation judges. My clients believe that that figure has been arrived at erroneously. We believe the compensation judge misapplied Minnesota Statute 176011, Subdivision 8A. We believe the compensation judge misapplied the case law that pertains to the allowance of departures as far as wage calculations are concerned. And we believe the compensation judge misconstrued the intent of the legislature in reaching the conclusions that she did. My clients are asking the court to vacate the finding of 3155 and 40 as far as the average weekly wage is concerned. My clients ask the court to find that a departure from the construction wage statute is required in this particular case, and it has been mandated in the past. Examples would be the Loberg case and the Ross versus KAS case. My clients ask the court to adopt the average weekly wage instead of $1,375.00 per week, based upon the alternative method of calculation that we proposed in this case, which is based on historical earnings of the season prior in 2021, also based upon the detailed analysis of the vocational expert, Ms. Groby. Finally, my clients are asking the court to order a 20% reduction. If you reduce the average weekly wage to what we're asking, to $13.75, that will result in an overpayment based upon the previous average weekly wage. So we're asking for a 20% credit going forward to future benefits. I believe the 315540 has been reached due to several misunderstandings of the law, which is understandable because I think the law is very nuanced on this particular topic. First, I think there's a mistaken belief that fairness is for the legislature to consider and not for the courts to consider. But I think the Bradley case stands for the proposition as far back as 1987 that fairness is explicitly a factor for this court's consideration. The overarching object of wage calculation in all of these cases is to reach a fair approximation. So clearly, fairness is an issue for this court to determine. Second, mistaken belief that the construction wage formula is somehow special and not like the rest of the wage calculation statutes. That's simply not the case. Some of these cases refer to the use of the mandatory language shall, and just because the legislature is using the term shall, therefore any result produced is unassailable. But that's not the case. All of all of the wage calculation statutes are phrased in mandatory terms. They all use strong shall-like language, and they've all been subject to the same rules on departure for 30 or 40 plus years. The construction wage statute is no different. There's been some arguments that the only exception to this construction wage statute is impossibility. In other words, there's simply not evidence to comply with the statute, and that's the only basis for departure. But that's been clearly disproven in that Koziolik versus Aconite case, where the court had all the evidence necessary to strictly comply with the terms of the statute and nonetheless chose not to. So impossibility isn't the only exception. There are, in fact, two exceptions to the construction wage law statute. The first is what I'll call the primary exception. This is the exception that applies to all the wage calculation statutes based on the law as it stands. And that particular standard is if the case involves an unusual fact scenario where a party is able to prove that the actual earnings prior to the date of injury are an unreliable indicator of earning capacity. If the parties can prove that, then a departure is warranted. That rule applies to all of these statutes, including the construction statute. The construction statute is special insofar as there's an additional departure that applies to the construction statute, and that is the departure that was outlined in Koziolik. And that departure says that if the end result produced by strict compliance with this particular statute produces a result that goes far beyond the objectives of the legislature, then a departure is also permitted. So
Thank you, counsel. I'm going to stop you right there. Do either of my colleagues have questions?
My first question is just simply, I looked at the the evidence and the calculations. And there's no dispute, I don't think, that the calculation is correct. And the underlying information going into the calculation is also undisputed.
Correct. The court has all the information it needs to strictly comply with the statute if that's what the court decides to do.
And so there's no dispute that the 315540 is been calculated correctly. There was substantial evidence in the record to support that calculation.
I don't agree. Yeah, I agree that the 3155 is based on substantial evidence that's been submitted. What I don't agree with, though, is that the earnings in 2022 are a reliable indicator of Ms. Buckwalter's earning power. So we're not disputing that the evidence supporting the 3155 is there and exists. We're just arguing for a departure because it's unreliable evidence.
Mr. Kaczynski, well, first of all, I guess I don't understand why it's not reliable. There was no alternative evidence as to what else her earnings may be, right? And there was 20-some weeks worth of records?
The reason it's a twofold reason for why it's unreliable. So the first thing has to do with the timing of the injury. So the injury in 2022 occurred early in the season. She'd only worked 46 days prior to the injury. So that's an issue. It's similar to the Loberg case in that respect because the timing of the injury has set this up where it's going to produce inherently an unreliable calculation of weekly wage. The reason being, in the 46 days that she worked prior to the injury in 2022, 33 of those 46 days were spent working on a large prevailing wage project for the Minnesota Department of Transportation. And what prevailing wage does is it exaggerates the earnings. So the testimony and the evidence is that the negotiated rate for Ms. Buckwalter was $25 an hour in 2022. However, on prevailing wage projects, the government sets the rate at $10.50 more per hour. That rate is exaggerated when she's working overtime hours on prevailing wage projects. So here you have.
Is that an exaggeration or an inflation?
It's an inflation, either way.
Well, I guess I'm not understanding then how a prevailing wage escalation or inflation is different than, if I'm pronouncing this correctly, Pekowski of overtime hours. Isn't it the same thing? It's extra money for extra time spent, and that's part of the evidence that was in front of the compensation judge.
The problem here, though, is again, we're having to focus on just 46 days due to the way the statute is worded. 33 of the 46 days were spent working on prevailing wage. However, the credible testimony in the case is that prevailing wage work for Fahrner as a business is uncommon. Prevailing wage work in Fahrner's business only accounts for about 10 to 15% of projects that Fahrner does. But just due to the coincidental timing of this particular injury, she had been working on a large prevailing wage project for 33 of the 46 days. So if you apply the statute in this case, the result makes it seem like Ms. Buckwalter is working on prevailing wage projects all the time and is being paid prevailing wages all the time. But the evidence is all to the contrary. The evidence is actually she only works on these projects 10 to 15% of the time, and that her actual rate of pay is much lower. It's $25 per hour. So that creates the unreliability of the evidence in 2022.
But the compensation judge had noted in her memorandum that perhaps the employee, Ms. Buckwalter, would be able to take her skills and go to employer where they have more prevailing wage. She has shown the ability to earn that. Would you agree with that?
My position on that is that's pure unfounded speculation. So we had the vice president of the company come in and testify, and he testified that prevailing wage is uncommon not only for Fahrner, but it's uncommon industry-wide because all these different companies are competing for these jobs. The testimony by the vice president of the company was actually that it would be unreasonable for Ms. Buckwalter to assume that she could ever work prevailing wages the majority of the time, that she would ever be able to work on prevailing wage projects the majority of the time. Yet the result of applying this particular statute does just the reverse. It presumes and imputes full-time prevailing wage work to Ms. Buckwalter. It treats her as if she's working prevailing wage work all the time, when the actual credible evidence in the case is that that's not a reasonable belief based on how this industry actually works.
Let me ask you a slightly different question. She was injured on June 21, 2022, after 33 days on this prevailing wage job. How long after the date of injury did that prevailing wage job continue?
I can't answer that question. That's not in the record.
And I'm forgetting the name of I think it was the co-president that testified, but he also said it varied year to year. 10 to 15% was kind of the number that he threw out. But he did say that it varied year to year, right?
That's correct.
Okay.
That's correct. But again, he has a long history of the company, and he has the foundation to provide that type of opinion. And 10 to 15% is obviously a much different figure as opposed to the result the statute creates, which is working on prevailing wages all the time, being paid prevailing wage rate all the time. So I think the testimony is certainly relevant and proves that the way the statute functions here renders those actual earnings unreliable. The alternative method we proposed is relying on the wages from that prior season in 2022, taking a look at the earnings over the course of the entire season, which includes overtime, it includes prevailing wage work and everything else. But because we're not focusing on an uncharacteristic amount of prevailing wage work in just 46 days, because we're able to see the work over the course of an entire season, that's eliciting a number that's actually a reasonable, fair approximation of what her earning capacity is.
But Mr. Kaczynski, the case law makes it pretty clear that the only time you deviate from the statute is if the evidence isn't clear, there's not enough evidence, and I think you've already agreed that the evidence here is clear, the calculations are clear, or that failing to deviate would result in an absurd result. So, and certainly the case law has also said that you can look at past earnings or co-employee earnings if there's a lack of evidence. But in this case, there's not a lack of evidence.
And therein lies the misunderstanding, though, because just having the evidence necessary to comply with the strict terms of the statute doesn't end the inquiry. If it's proven that those earnings are unreliable for some reason, as we think they are, then a departure is warranted. There have been several cases. The most significant would be Loberg and Ross versus Cass, where the judge had all the evidence, applied the strict terms of the statute, and once it got up to this court, the court said, no, you shouldn't have done that because those earnings are unreliable, and actually remanded the case back to the judge specifically saying the statute should not be complied with. That's exactly what we're asking the court to do today, and it's based on those earnings from 2022 being unreliable due to the uncharacteristic work that was being performed in the very narrow window that that statute requires the court to focus on. It's much more reliable to focus on the season before in 2021 because you get to see over the course of an entire season how much overtime, how much prevailing wage, how much straight pay. And we're not talking about a big difference in time here. We're talking about the season in 2021 and then the layoff period and then the season in 2022 where she worked 33 days. It's not like we're trying to go back 5 years and attribute things.
Well, in 2022, on this particular job, the prevailing wage job, she was getting a per diem, which she may have not gotten in 2021. Is that a fair understanding of my
She
part?
was paid per diems in 2021 and the wage records are extremely detailed. So all that's information is contained.
But one of the other things, she was working a lot of overtime on this prevailing wage job. I mean, there were days when she was working 18-hour days. Was that, I didn't see or look that closely in 2021. Was that the same?
There was a lot of overtime in 2021 as well. And there's no dispute that overtime shouldn't be included. There's no dispute that prevailing wage shouldn't be included in the calculation. The dispute is just the statute is requiring us to focus on just these 46 days. And 33 of those days, she was working an uncharacteristic amount of prevailing wage, being paid at rates much higher than she typically is. Again, you're dealing with a situation where prevailing wage projects are 10 to 15%. And what this statute is asking us to believe, or is asking us to accept as true, is that she's working prevailing wage projects 100% of the time, being paid these higher prevailing wages 100% of the time, which is simply not accurate. Thank you.
Thank you.
Thank you.
You can reserve your 12 seconds for a rebuttal if needed. Mr. Garvey?
Thank you.
Thank you.
Good morning. I am going to jump around a little bit because I feel like your questions have kind of changed the structure of what I was going to say. But I would first note that what we've done is clearly apply the statute. We feel that statute is clear, unambiguous, unequivocal, tells us exactly what to do, and that's what we've done. With regard to the prevailing wage, prevailing wage, there's nothing to suggest that that's any different than any other earnings someone has. It's part of the calculation. There's been no argument that prevailing wage should not be included. Mr. Kruko or Mr. Kaczynski is calling for a deviation primarily based on 3 cases in support of that contention, but I feel that those cases can be easily distinguished. He refers to the case of Bradley versus Vicks Welding. However, that was a case that involved an individual that was hired out of a union hall to work for a specific 3-week period of time at the employer, wherein that was the only period of time at that employer that overtime was worked. The court looked at that situation, felt that individual should not get the benefit of the overtime. That's entirely different from the present case. In the present case, Ms. Buckwalter was a regular full-time employee, worked regular overtime, very different type of case. He relies on the Loberg case in support of his contention. The Loberg case was not a case involving this particular statute. It was not a construction seasonal wage case. The Loberg case involved a registered nurse who normally worked 2 jobs historically. However, right before her injury was laid off from her second job. The court looked at that situation, determined the judge should have some discretion to consider the wages from the job that she was terminated from, and therefore allowed a deviation. But that's very different from our present case. Our present case involves a construction worker and is a very different matter. The only case that Mr. Kaczynski presented that really addresses this specific statute is the Koziolek case. That did involve an analysis of the seasonal construction wage formula of 176.011, specifically the 5 times the daily wage requirement of that statute. In the Koziolek case, that involved an employee who, and an employer who allowed their employees to work 4 days a week, 10 hours a day, every week, almost as if there was a agreement in place or a contract to an extent that that's what everybody works. There was no overtime involved. I was a very specific, unique set of circumstances. The employee tried to argue that they should get the benefit of the 5th day portion of that calculation, but the court essentially said that's a bridge too far. You always worked 4 days a week. You always worked 10-hour days. You didn't get any overtime. The judges allowed some discretion. But that's very different from the present case. Ms. Buckwalter is a full-time employee. She's got a multi-year history with this employer. She's regularly worked overtime. She's regularly earned prevailing wage income. We're not asking the court to go too far here. We're applying the statute directly as the court has instructed us to do so. Alternative to the cases presented by Mr. Kaczynski, in my brief, I outlined the cases that support our position. The primary case in that regard is the Palkowski case. The facts of the Palkowski case align pretty cleanly with our situation. It involved an employee that had worked 40 days in the 26 weeks prior to the date of injury, which is just about spot on with the Buckwalter situation. So the court was analyzing a similar period of time and a similar set of wage records. The insurance company argued that because the resultant average weekly wage was too high, that the court should deviate from application of the statute. The Palkowski court denied that argument and noted several things, which I'll start here. I suspect you're going to jump in, but the court noted that the construction seasonal wage formula of 176,011 represents the legislature's choice with respect to how a fair approximation of future earning power is to be achieved in the case of workers whose hours are irregular and difficult to determine and who are employed in industries affected by seasonal conditions. Additionally, the court noted that the defense in the Palkowski case made the same arguments, pointing to Kozoliak, arguing that that allows for a deviation. The Palkowski court clearly distinguished Kozoliak, similar as I did here today, noting that that was a very specific set of circumstances involving someone working 4 days a
I'm
week.
sorry, counsel. I was listening to you and stopped looking at
I
my
know,
clock.
I was looking at it,
You
wondering.
should have stopped me. Stop you.
I paused.
Thank you.
My question would be the same. I mean, the calculation that Mr. Kaczynski, the calculations and the information going into those calculations, there's no dispute over that, is there?
Not to my knowledge.
And my question is, and I agree with you that Palkowski is very much on point. Again, it's overtime hours versus prevailing wage, but the facts fit. And in Palkowski, this court said, even if the actual earnings versus the imputed earnings, if there's an extreme disparity, even with that, there's a statutory mandate for the average weekly wage. So my question for you is this. When does an extreme disparity between actual and imputed get to the point where it's absurd? The facts in this case are that she's going to make more than a foreman would. She's going to make more than double of what people, of her skill level is going to make. At what point does it become absurd?
I don't know at what point it would be considered absurd, but I don't believe that this is a case where it would be considered absurd because, as you noted earlier, Mr. Krakow testified that prevailing wage varies at that employer from year to year. There's no evidence presented as to the summer of 2022, how long that prevailing wage continued. She did, when you look at her earnings leading up to this date of injury, had weeks where she was clearly eclipsing the average weekly wage that we've asserted in this case. So it's hard to say that the average weekly wage arrived at is absurd if she actually had earnings leading up to the date of injury where she earned that amount. Similarly, as Judge Marshall noted in her decision, and you mentioned today, Ms. Buckwalter's not stuck at this job forever. She could have moved on to different employers in this line of work who do more prevailing wage work. So even if it hadn't been with Fahrner, as Mr. Kaczynski suggests, she certainly could have gone otherwhere and earned those sorts of wages. And I would also note that, as you mentioned, I mean, in Pelkowski and the several cases that follow that I referenced in my brief, the court consistently says, yeah, applying the statute in the fashion as directed is also often going to result in an increased imputed average weekly wage, but that appears to have been the intent of the legislature. Similarly, a lot of these cases took place before the year 2000 when this question was being raised. This sort of question was being raised. In the year 2000, the legislature amended the statute that we're talking about today, added the language indicating that the court should factor in proportional days into the calculation. And when you dig into these, anytime you do that proportional day math, it's going to increase the average weekly wage. So while there was lots of arguments pre-2000 about, hey, this seems funky, maybe the legislature needs to address this, the legislature did address it in the year 2000. They amended it in a fashion that arguably made it more favorable to employees by adding that proportional day language. So the results here are a result of applying the statute directly as the legislature instructs us to and intended us to, and the results are what they are. I would also refer you to the case of Carter versus Elcon. It's in my brief, where the insurance company argued that, wow, look at this imputed average weekly wage as it compares to what she earned the year prior, right? That's a huge disparity. We shouldn't do this. And it was over a 4 times increase, which is way more than what's happening here. And the court in that Carter case didn't blink an eye on it, said, that's the result of the calculation, it is what it is. So that's the best way I can answer that question.
Thank you. You would agree that it is appropriate on occasion to not have a strict application of the statute of 8A?
Sure, there are circumstances where the court has deviated, and I understand why. I guess if the court is considering a deviation in this case, they need to look closely at Mr. Krukow's testimony about how uncommon prevailing wage is. I outlined that in my brief, and I would again point that he says it varies from year to year. But if you do some of the math with respect to the assertion that only 10 to 15% of the employees' work is generally prevailing wage, doesn't seem very plausible. Judge Marshall had a chance to listen to that testimony, which was essentially all just verbal testimony, and she didn't adopt it. But if you dig into that a little bit, you know, before, in the year of her injury, before she got hurt, she had spent 70% of her days doing prevailing wage work. So it's kind of hard to say it's super uncommon, but she just spent 70% of her time working prevailing wage jobs. Similarly, the notion that, or an argument perhaps that, well, she wasn't going to work anymore that year. That was it. That was all she was going to get. That's hard to believe, because if you do the math on how long a typical season is, by June 22nd, if she had worked that much prevailing wage, she's already at about 20% of what the year would likely be. So to suggest that she was never going to work another set of prevailing wage jobs in the rest of June, July, August, September, October, it's hard to accept that, I think. And I think that is, Judge Marshall likely didn't find that very believable. The other thing I would note is, if the court is considering a deviation, they cannot adopt the average weekly wage asserted by Mr. Kaczynski here. That average weekly wage is based on 2021 earnings, so the year prior, that's fine. The statute tells us to look at the 26 weeks preceding the date of injury, so it's out of line with the statute. Ms. Buckwalter was earning 5 to 7 $2,246.50 less per hour in the year 2021. So he wants us to jump out of a proper time period, look back at a year where she was earning significantly less per hour, and then also not actually apply the statute, right? So despite those two things, he also looks at 2021 and says, let's not even do the seasonal construction wage formula. Let's not factor in the proportional days. Let's not figure out the daily wage as called for by statute. Let's just do a whole nother calculation because to us it seems more fair. So there's some major flaws with how that average weekly wage was determined from our perspective, and I don't believe the court can adopt that.
I do have one more question for you. Mr. Kaczynski started by saying that because this is application of law to undisputed facts, our court should do a de novo review. Do you agree with that?
Yes.
Thank you.
Mr.
I've got-
Garvey, you have 1 minute left.
Yeah, I'll just touch on a couple of other things. You know, the employer bids on these prevailing wage contracts, presumably for a reason, likely because they pay well, right? The employer got the benefit of Ms. Buckwalter performing this prevailing wage work. They got all that money, but now they're suggesting that Ms. Buckwalter shouldn't get that benefit. That doesn't seem appropriate. The other thing I would note is, were the court to adopt the average weekly wage that Mr. Kaczynski presents, I think the court can anticipate a lot more litigation in seasonal construction cases where anytime the employer isn't happy with how high the average weekly wage works out under the construction wage formula of 176,011, well, we'll just look at the last year because maybe we didn't have that much overtime last year, that much prevailing wage last year. So let's just run the calculation off of that and argue that that should be the wage. So I would be leery of that. Thank you.
Thank you. I think you have 18 seconds left.
I'll have to set my own timer for 18 seconds. The result here produced is an absurd result. It results in annualized earnings being imputed of $160,000 per year. There are no facts in the record that would warrant a finding that Ms. Buckwalter's earning capacity is the equivalent of $160,000 per year. Moreover, she's been working full-time as an administrative assistant at more than her hourly rate of pay at the time of the injury in 2022, yet my clients are still somehow liable for the max compensation rate based on TPD benefits. So we've created a position for her that's exactly consistent with the legislative intent of the statute, and despite creating that position exactly for her, not seasonal, year-round, full-time, higher rate of pay, we're still liable for max rate benefits. That can't be what the legislature intended. That's an absurd and unreasonable result. Thank you.
Thank you. Well, you both have presented very compelling arguments. We appreciate that. The record is closed. We'll have a decision out within 90 days. This case is concluded to that end, and thank you both.
Thank you both. Good job.
All rise. Court is in recess.
Nice job. I think I used to.
Okay. There you go.